Hi, everybody, and welcome. I'm Leslie with the New Mexico Small Business Development Center here with Anna Lena, and we're pleased to present Mr. Larry Donahue today. He is an attorney here in New Mexico that is going to be speaking to us today. He's going to talk about Trademarks 101. What are they and how do you get one, which is going to be an important topic for everyone. I just want to let you know that Larry always is very good about picking up any questions. If you have any, please type them into the Q&A and we'll get to your questions just as quickly as possible. So with all that being said, I want to turn it over to Mr. Larry Donahue.
Thank you. I appreciate it. And I hope everybody can hear me okay. We are going to be talking about trademarks today. And it's kind of Trademarks 101, but we'll be able to drill down to some interesting areas and we can get to Trademarks 404 by the end of this presentation, if anybody's interested. And as Leslie had said, I love questions. It helps me understand that people are actually paying attention and care. So we have the Q&A feature or the chat. Feel free to enter in your questions and I'll do my best to answer them while the presentation is going on. But before I start, I wanted to talk briefly a little bit about how the format of this is going to work. I also wanted to mention that the SBDC has a lot of great resources for you on the internet, and especially with the COVID stuff going on right now. So there's a lot of issues around OSHA guidance and CDC guidance. We have some links here on this presentation that is available for you if you need it. Before I continue, let me remind everybody, please mute your audio if you can. Also, we find that we're going to have some text and images in our presentation, and it'll look the best if you change your zoom ratio to fit window. Also, we talked about the Q&A function for taking questions, and then it also helps if you put in the slide number if you've seen I've moved ahead from what your question is. So what we're going to talk about today is I'm going to also bring up some other classes that the SBDC has available just in case you're interested over the next couple of days. And then we're going to talk about the trademarks, Trademarks 101. We're going to have questions and next steps for you. So before I begin, let me tell you there's a couple of other classes coming up tomorrow. Convincing followers to share your posts, your social media posts, the viral secret, that's tomorrow. On April 1st, COVID-19 related tax credits for small and mid-sized businesses. And April 2nd, profiting from social media, how to turn clicks into revenue. And I want to remind you that there's a lot of other on-demand outstanding training sessions with the SBDC that you can find on their website by going to their homepage. And then in the upper right, you'll see a webinars link. And then you can go there and search by date and topic. It's great stuff. So we're going to talk a little bit about what a trademark is, what can be trademarked, what can't be trademarked. The phrase likelihood of confusion is really important and very confusing. So I'm going to try and shed some light on that. And finally, how to register a trademark. So let's start with what is a trademark? And I think everybody intuitively knows, or they think they know what a trademark is, but it's more nuanced and it's more complicated than you probably think it is. A trademark is a source identifier. What I mean by that is it is something. It could be a word, a logo, it could be a color or a sound. When you hear it, when you see it, it immediately conjures up the company. It also should conjure up not just the company, but the attributes of the company. You know, when you think of a certain company, do you think of quality or speed, consistency? You know, so the trademark represents not just the name or the logo, but sort of the brand impression and market, you know, what the marketplace sort of instills on the company. And let me give you some examples here. So I'm going to show you some trademarks. And what I want you to think about is not just, you're going to know immediately who these companies are, but what does it mean to you? What is the emotional response? So for example, McDonald's. Your emotional response should probably be consistency. That is a huge brand trait of theirs. So you know, if you go to the McDonald's in Albuquerque versus the McDonald's in Chicago or Moscow or Tokyo, you're roughly going to see the same menu and the same taste. That is the McDonald's brand. And that logo, that trademark, represents that brand, not just the company by itself. What about this, right? What is the emotional feeling that you get from that? Or this? Now, these last two that I'm going to show you is a little different. What is that? It's a green garbage truck. And depending on where you're located, Waste Management may or may not have the local contract, but that green is Waste Management. And so when you see a green garbage truck, the connotation is supposed to be the Waste Management and what they do and don't do around, you know, facilitating trash. Is this one an interesting one? I bet you know who it is and why. So a trademark then can be a lot of things, right? It's a name, it is the logo, it could be a color of an object, it's really interesting. But let's talk about colors a little further because I think it's pretty interesting. And what I would like people to do is text back to me in the chat. Find the chat, and I'm going to show a color. And I'd like to see who knows what this color represents, specifically the company name. Does anybody know what this color represents from a company standpoint? Because this is actually a registered trademark, that color. Anybody want to text that to me in the chat on Zoom? I'll give you, somebody's Leslie stumped. Anybody else? So far, no guesses. Well, as soon as I show it to you, you're going to be like, oh, you knew that. Tiffany and Company, right? Let's try another one. Pink. Now, I gave you a hint with my previous slide on this one. It's going to be the fiberglass company. Does anybody know the name of that company? Okay, we'll move on. Owens Corning, exactly. Robert had it right. Yep. You guys have it. I wasn't patient enough to wait for you to type that all in. So I'll do that this time. So now here's another color, pink. So can companies have two different companies have pink? The answer is yes, as long as they're not confusingly similar. And we're going to discuss that in a minute. But does anybody know what this color pink represents? And I promise you, the moment I show you, you're going to be like, oh yeah, I remember. But I'll give it a few seconds. There we go. Catherine has it right. It's T-Mobile. Remember all the commercials? They go and make the telephone lines pink and, you know, trying to show the 5G networks. That's trademark. And you're not going to find another cellular company or communications company using that color because of it. How about this one? Now, this, depending on your monitor, may look black. That's true. Catherine did bring up, you'll see pink bands for breast cancer awareness. That's true, but that's not a registered trademark. That's just what they're using for, okay, Catherine brought up UPS. That's right. This color is a dark brown, and that's the UPS color. And you'll see that in their logo as well as their trucks. Finally, one more, this one. And I'm not expecting anybody to guess this one, but you might be surprised actually. I'll give you a hint. It has something to do with paper. I'll give you another hint. It has something to do with glue that won't stick. That was too big of a hint. Just turn that off. Sticky notes. Leslie got it right. That's correct. Post-it. That's right. 3M specifically. That's a trademarked, branded color, interestingly enough. So what have we learned so far? Trademark is a unique symbol that uniquely identifies the source of a product or service. And so what do I mean by that, the source? Well, when you saw a color, like nobody could guess Tiffany's, but I know when I showed Tiffany's, everybody said, oh yeah, but that's the point. That's what a trademark does, is it identifies the company. So you don't want, what we're trying to do here is protect the public so that you can be assured that this particular mark is going to be associated with a company that you think it is associated with. And so there's some really interesting issues here that a lot of people don't realize. One is it has to be used in commerce. You cannot have a trademark that isn't being used in commerce in some way. Now there's an exception, and that's called the intent to use. And what that means is you can register a trademark for a very limited amount of time, but you got to start using it. If you don't use it, then you lose it. So it has to be used in commerce. It has to be a product or service sold to the public. It can't be a private sale between you and your cousin or some private employees somewhere. The other issue is it cannot be confusingly similar to another trademark. And this is a big issue that a lot of people misunderstand, and we're going to spend quite a bit of time on that. It cannot be descriptive for its intended use. We'll discuss that a little bit more as well. But what we can't do is take colors, sounds, words out of the human language. So you can't take a dictionary word like the word apple and trademark it for the fruit. Can't do it. But you can trademark it for a computer company, for example. There are other rules and requirements. And if we were to print it out, it'd be about a 3 or 4 inch stack. It's crazy, outrageous, all the little exceptions and nuances. But I put some big ones here that, kind of like duh or no duh, but, one, it can't be immoral or scandalous. There's this First Amendment issue on swear words, for instance, and I'm not an expert on any of the details here until a client brings me a project. And now all of a sudden I got to dive in and figure things out. And I have one client who wants to use the 4-letter word that starts with F, and my client can't decide if he wants to use F with an asterisk symbol in it, and then the rest of the remaining 2 words, or if he wants the U in place of the asterisk. And I keep telling him over and over and over again, asterisk, asterisk, not the U. And he wants to argue with me on, First Amendment grounds. And what's interesting about the First Amendment is it limits the government. It doesn't limit Amazon or other third-party companies. So while maybe we might be able to push through a trademark that might be considered somewhat scandalous because it has a swear word in it, we're not going to be able to potentially use that in key marketplaces, eBay, Etsy, Amazon, stuff like that. At any rate, other issues with trademarks. It can't be geographically significant unless it's permissible. And it can't be geographically misdescriptive either. And I'm going to give you some examples on some of this. You can't use a surname. That's your last name. You can't trademark your last name. You can have your last name in a trademark, but pretend it doesn't exist for trademark purposes. And I'll explain what I mean by that in a few minutes. Can't be deceptive. We can't, falsely convey a meaning or connection to another party that doesn't exist. We can't pretend we're a government entity, for instance. And then there's some subject matter that's protected by statute. And I'll give you an example of one. Olympics. That is a statutorily protected name and mark, and so you're not allowed to use it. So how is a trademark protected? What are the options? And there's 3 levels of protection. And I'm going to start from the bottom here. That's common law. So if you're using a mark to identify your business and you've been using it for a long time, you have some protections available. It's called common law protections. And I say it's very little protection, only from the standpoint of if somebody on the other side of the state border is using it in Texas, Colorado, Arizona, there's nothing you can do about that if they were using first in their state. So common law protects things on a state-by-state basis. The advantage is you don't have to register anything, and it automatically provides some level of protection, but its goal here is really to protect the public, not to protect your name and give you a valuable interest in the name. The benefit here, though, is you can protect some descriptive terms in certain limitations. But all of this can be easily overridden if somebody else does some of the other stuff higher up on my list here. So the next level of protection is state registration. And what that means is you can actually register your trademark with the state of New Mexico, for example, if you wanted to. The disadvantage of it is if somebody does this at the federal level, it's going to override whatever you do at the state level. You would want to do something at the state level if you cannot do it at the federal level for some reason. So what I always tell people is start at the top of the list and work your way down. If you can't get a federal mark for some reason, then move down the list. But the one reason you want to be careful of is if you can't get a federal registration because somebody else has a mark, then you're in trouble. You don't want to use it. Otherwise, you can find yourself dealing with a trademark infringement lawsuit. And we're going to talk a little bit more about that in a few minutes. So why is trademark infringement a big deal? It's a big deal because there are a lot of penalties. I use the word outrageous here. If somebody has a trademark, a valid US trademark, and you are using a name that is likely to confuse, and I'm going to discuss what likely to confuse means, they can sue you. And when they sue you, they can get a restraining order, an injunction, they can get attorney's fees and court costs, which means if you think this is unfair and you want to fight this and you lose, you pay their legal bill. If you want to go and fight this, they can disgorge profits. What is disgorging profits? I'm glad you asked. It means you made a ton of money on this name for the past 7 years, and they can then say, we want to know what your profits were, and they can force you to pay them your profits for using their name. So you don't want to do that. Also, lost profits. The difference between lost profits and disgorging profits is disgorging profits is your profits that you have to give up to them. Lost profits is what they claim they lost due to your infringing activity. And then finally, if there's instances of willful infringement, and what is that? That's a discussion, a whole hour discussion on its own on what is willful. But I'll give you an example. If they said, hey, you better stop using this name, and you don't, that's willful. From the moment you receive notice onward that you didn't change your name, they can claim willful infringement, and that has statutory damages potentially associated with it as high as $2 million for infringing use. So do not infringe a trademark. So how do we do that? How do we not infringe a trademark? Well, that's going to depend on a couple of factors. One is, can you trademark your name at all? And if so, that means somebody else can trademark it. And we need to make sure that somebody else hasn't done that. And we've also applied the likelihood of confusion test to our mark to make sure that there aren't other marks out there that may not be an exact match or direct hit, but they're still going to be considered likely to confuse. But before I jump into likelihood of confusion, because that's a little bit of a complicated and confusing topic, I want to make sure you understand that a trademark also can't be descriptive. And so that is going to protect you too. And let me explain what I mean by that. This spectrum I have here on the left are generic names, on the right, arbitrary. And so let me pick on Apple. I picked on them a little bit ago. I'm going to continue to pick on them. If we can use the word Apple in a generic way, meaning I'm talking about the fruit, that if I open up the dictionary and I look, what is the definition of an apple? And we all know it's a fruit. So if I want to use the word apple in a descriptive, generic way, we're permitted to do that. So if you have an apple farm and you want to call it Apple Farm, you are permitted to do that. And you don't need to worry about infringing somebody else's mark because you're using it in a descriptive way. However, if you want to use the word apple for something that has nothing to do with a dictionary phrase or word, such as a computer company, and you want to name a computer company Apple, you can do that, but it's an arbitrary use of the name for the product or service you're intending to use it for. And therefore, that's a great, strong trademark. But a strong trademark means you can run into problems if somebody else is potentially using that. So what I tell people is step number one, pick a name that's not descriptive because you can't protect it. What you can protect are suggestive and arbitrary phrases and words and meanings. What is suggestive? Well, a Greyhound bus would be an example of a suggestive mark, because, or maybe arbitrary. It's somewhere in the middle there. Greyhound implies sleek, fast. You know, they have a bus company that's fast, or they're trying to promote it as fast. And so Greyhound is a great name because it means a dog, doesn't mean a bus company. But the word Greyhound bus, the bus on the phrase Greyhound and bus is not protectable. So you can have other companies that can have the word bus in it, just not the word Greyhound. What I deal with in New Mexico are a lot of people that say, they want to say like Albuquerque's best. And they can certainly do that, but you can't protect it because everybody's permitted to use the word Albuquerque's best when they have, you know, something in Albuquerque. But there are some exceptions to that if you threw $1 billion at something and became famous. And I'm not going to talk about that because I'm assuming I don't have any $1 billion companies watching this video. But if that's wrong, let me know, and I'm happy to talk about famous marks. So let's talk about this next piece, and that is the likelihood of confusion. So you're going to come up with a name that's not descriptive, and you want to make sure that you can use it and somebody else isn't using the mark. So what we care about is it's a test called likelihood of confusion. And if you violate the test, you have two problems. One is you have infringement with somebody else using the mark. And two, you're not going to be able to get your trademark because it bars registration. The United States Patent and Trademark Office, the government agency you would send your federal trademark registration into, is going to reject the mark. And what the test basically says is, will likely consumers be confused, mistaken, or deceived as it relates to the commercial source of the product or service that the mark is identifying? Now, if you have a problem with likelihood of confusion at the federal level, do not think you can go and register your mark at the state level. You could do that. And guess what? The Secretary of State will probably approve your application, but that does not mean you're not infringing a federal trademark. The New Mexico Secretary of State does not do a likelihood of confusion search and test before they approve the marks. So just because you have a mark that's approved at the Secretary of State with New Mexico does not act as a defense. It's not going to protect you. And definitely common law isn't going to help you at all either. So what is likelihood of confusion? Let's, how do we put some meaning around that? So what you want to ask yourself is there similarity, not same, similar in sound, look, meaning, or commercial impression? And so we also care about the relatedness of the product or service. And so Apple, I'm going to use this as an example, and it's really a bad example because it's a famous mark. Famous marks are given more breadth, more protection than your standard mark. But if you wanted to open up a locomotive in, let's say a electromotive, you're going to put in motors for trains, and you wanted to call it Apple engines, you could probably get away with that because there's no connection, no similarity between computers and engines. But as I said, Apple is a bad example because it's a famous mark, and I would expect Apple to probably have a problem with it. But if there was another trademark out there that wasn't that famous and they were in a totally unrelated area, you could probably get away with it. But let's talk about that a little bit. So in my experience dealing with trademarks, the US Patent and Trademark Office has come back after me saying coffee is related to donuts. And so we had a client in town, a pretty popular donut shop that tried to register their trademark, and the USPTO came back and said no, because there was a coffee company of the same name. And so you might think, okay, that kind of makes sense. Maybe you go to a donut shop and you're going to expect to find good coffee and vice versa. Well, in this particular case, the coffee was not in any donut shop at all. It was in the supermarket, and it was a canned product, and that was okay for the USPTO. Perfume and sun tanning lotion are considered related products. I still don't get it. Doesn't make any sense to me. Sun tanning lotion versus perfume seem to be very different products. Yes, there's an odor to them, but I would assume people buy perfume for the odor. They buy sun tanning lotion not for the odor, but for the intrinsic qualities of protecting themselves from the sun. But the USPTO disagrees with me, which means that my client, the perfume company, has a problem because they could potentially get sued by the sun tanning lotion company. Coaching and consulting, that kind of makes sense, maybe. Coaching seems to be a very different product. It seems like to be more like one-on-one with people versus consulting where you're dealing with business issues, but the USPTO feels otherwise. This one kind of makes sense. Websites versus retail stores. So you can have a retail store, never been on the internet at all. And if they have a trademark, they're going to create problems for anybody that's just trying to do business on the internet or the web. Now, this one is going to probably surprise you. Expensive watches and luxury cars. The USPTO has come back at us saying that they viewed them as similar. Now, that's ridiculous, right? How does a watch have anything to do with a car? Well, the USPTO said these are luxury items that only a certain demographic, people with high net worth, are going to know about, and they are going to associate those brand names with the luxury items, and therefore they felt you could create a false commercial impression using a name for an expensive watch that might be confusingly similar to a luxury car. Now, these little categories I put here are not the only related products and services. I'm just trying to give you examples of how things might be a little surprising, because you say, I'm in the tortilla manufacturing business, so you're making food items, but where are you selling them? Are you selling them in a retail location? And guess what? Tortillas are going to be similar to bread possibly, or other manufactured or baked goods or items. So you can't just look and say, there's no other tortilla companies with my name. You have to expand that to other potential business or related businesses, as well as maybe where it's sold or how it's produced. But let's talk about the big issues on similarity of the name. This is the biggest issue that causes problems for people. And so Similarity, similar. What does that mean? Well, it means synonyms. So box and cube are going to be considered the same for trademark purposes, even though they're very different words. And we just got a question from somebody in the chat. If I have a mark that is similar to another mark, but the names are different, that is likelihood of confusion. Well, if it's similar, it could be infringement, absolutely. So when you say the mark is similar to another mark, is it similar in look, sound, or meaning, or commercial connotation? So I'm going to go through a few more here, and hopefully it might answer your question. Abbreviations are also going to be a problem. So lux and luxury are going to be considered the same for trademark purposes, even though they're clearly two different words. Translations are also going to be a problem. So red and rojo, for example, is going to be a big problem. And it doesn't have to be translations for Spanish and English. I'm seeing problems with Dutch, Japanese, Chinese, French, Italian. So you have to really be this savant that can at least look up some of the more popular foreign translations of some of your words to see if you might have a problem. And then also get this, made up words can be a problem. Like this, millennials love to use the little 8 symbol that, 8, the spelling would be like ATE, and so they'll substitute the number 8 for those 3 words, ATE. So this word translate, now I took out the A as well. It seems like millennials, using their thumbs will take out the vowels. So this translate means the same thing as the actual word spelled out, and that could get you into trouble as well. So common words found in a similar industry, even though they're very different. Athletics and running, isn't that crazy? So I had an issue with somebody using the word athletics for a running shoe. And the USPTO came back and said, nope, and there was another shoe out there that had the word running in it. And actually it wasn't it's shoes, it was athletic clothing. So the USPTO associated those 2 marks together. So athletics and running wouldn't be a big deal if you were in a different industry. So let's say computers again, or consulting, that might be okay. But if you're going to be in the running business or the athletics business, then you have to think about words that could be associated with your word. Other different forms of the same word. So adapt and adaptive are going to create problems. And you can imagine all the different root words and connotations you might have. So you have to think through that. And if you're using a word like adaptive, you really want to do a search and trim down that word adaptive and just look for adapt star or, ADAP star and see what else comes up. And then the other thing the USPTO does is they place a higher value on the first word, prefix, or syllable, even if the remainder of the trademark is very different. So using adaptive again, if we said adapt athletics and more, because somebody has the word adaptive, you have the first word adapt, they're going to be similar, and the USPTO is going to flag this and reject it, even though you have other words in your trademark to help distinguish your mark from the word adaptive. And it's not intuitive, because if you just look at those two, adaptive versus adapt athletics and more, I mean, they're 2 very different phrases, yet they're going to be considered the same for trademark purposes. Otherwise, a likelihood of confusion, similarity. We have other problems. Additional words may not be enough. And I think you probably figured that out with the previous one, but it's really important to understand. You could see somebody with 1 word trademark, and then you can bury that 1 word in your mark, and you may still have a problem. Now, Google is not a great choice for my example, by the way. Why? Because it's a famous mark. Stay away from famous marks. So you can imagine Google's going to have a problem with this because it's going to look like this is associated with Google somehow. So that's going to be deceptive and not permitted as well. And I could potentially have a trademark infringement lawsuit against Google. But if Google was not a famous mark, I'd still potentially have problems with it because they have the one name, and just by putting it and putting other words around it might not necessarily be enough for me to avoid trademark infringement. Finally, what you need to understand is descriptive terms are invisible. So Larry's Fast Machine Learning, if I wanted to have a machine learning company, so, computer programming, and I wanted to use my first name, I can certainly do that, by the way. There's nothing wrong with me trying to trademark Larry's Fast Machine Learning. However, fast machine learning is a descriptive term for what I would do, and so you pretty much just pretend it's not there for trademark purposes. So what we're left with is the word Larry's. And so we want to look at the word Larry's and see if anybody's using the word Larry's or anything confusingly similar, synonyms, abbreviations, translations, in the industry and related industries that I am doing business. And if we were to look above at children's learning and Google Play, and let's pretend it's a bouncing gym. Well, the word children's is probably descriptive because we're going after children. So I would pull that out. The word and, we're not allowed to protect that at all. So pull that out. We're left with learning Google Play. But it's a bouncing gym, playing, so that goes out. We basically have learning and Google. And those would be my two terms they're going to distinguish my mark from others, the distinguishing characteristics of my mark. And that's what you want to focus on to see if it's unique and not confusing to any other marks out there. So can you trademark any of these names? We're going to go through a little test here and see if you were able to learn from my previous slide. What goes into producing a good name? McDougal's for a fast food restaurant. Can we do that? Anybody want to text me a yes? Or is everybody going to say no on this one? I'm going to say no because of McDonald's. It's spelled differently, but it sounds similar. It looks similar. It's a problem. And plus McDonald's is famous. What's the rule? Stay away from famous marks, period. If I had a nickel for every time somebody called me and said, well, I removed the space and I added an S at the end, right? We know now that doesn't matter at all, right? Adding a space, removing spaces, pluralizing, not enough to get out of this issue of similarity because it's still going to look the same. It's still going to mean the same. It's still going to sound the same, or it's going to sound similar. Federal Express for a shipping company. That's right. Well, so Robert brought up a point. He's talking about the movie in McDougal's, and the Golden Arches got him in trouble, absolutely. But the movie was wrong. You're not allowed to use your name if there's another name out there that would be confusingly similar. You're not allowed to do it. The other thing is surnames cannot be protected. McDonald's, well, I know there's a lot of McDonald's out there, but McDonald's supposedly, allegedly, when the trademark came around, there's some exceptions that allowed him to get the trademark McDonald's. But McDougal would have a problem with the name, not just the Golden Arches. Federal Express cannot be used either for FedEx. Now, the reason I brought that one up is I've had people, so FedEx is kind of an acronym, an abbreviation for Federal Express. You know, we see those a lot out there. IBM for International Business Machines is something that comes to mind right away. So those companies that are trademarking their acronyms, they still also end up trademarking their name, whether you know it or not. And so you're going to run into problems even though you're not using the same name as the acronym. How about Apple Farms for an apple farm? That's not a good name either, is it? I used that as an example earlier. That's descriptive. So that's not a good idea. How about Homestead Office for a movie company? Anybody have any thoughts on that? It's not too general, but the problem is we have something called HBO, and their home box office, I believe, is what they are. If I'm saying that right, I forget what the H is. It's either home, yeah, I think that's what it is, home box office. And so Homestead Office, just because we got rid of a word and changed the first word, probably isn't going to be enough to get out of the similarity, and we're going to have trouble with HBO. And again, I would argue HBO is probably a famous mark, and so stay away from that. Digest for readers for a book company, right? Hopefully we all know no to this one. And the reason being is we have Reader's Digest. Just moving words around and adding another word in between isn't necessarily going to save us from the name. Albuquerque's Best Hamburgers. I think I brought that up as an example earlier in this presentation, didn't I? The answer to this one is going to be no. Descriptive. If remember, I say a hamburger restaurant in Albuquerque. So we're describing what this restaurant is. We're not going to be able to protect it. And guess what? It's not a good name, because if you Google it, it's going to have 50 million hits. Is that the kind of business you want? That's going to, people try to Google you and call you and they get lost because there's 50 million other hits showing up? The answer is no. You want to be a little more clever. And it's hard to be clever. And I'll tell you, I'm not clever. I didn't come up with my name for my law firm. I actually hired a brand expert to help me with that. And it takes time and effort and money. And the really good names are the hard ones. How about Albuquerque's Best Hamburgers for a hamburger restaurant in Santa Fe? Does this work? Because now we're not describing it, right? Because it's in Santa Fe. Is this okay? Anybody want to take a guess? It is confusing, Catherine, but it's misdescriptive. It's basically the actual word for it in trademark law is geographically misdescriptive, but it could be considered, like deceiving. And so we can't use a name like that. How about Albuquerque's Best Hamburgers for a dog food company? Would that work? It's not describing the restaurant. It has nothing to do with the geography. Can we do this? The answer is no. Deceptive. I'm assuming you're not actually putting real hamburgers in the dog food and making it the dog food. So that would not be permissible either, and that'd be considered deceptive. And interestingly enough, that could maybe get you sued by a lawyer out there claiming, consumer deceptive practices. So you want to avoid something like that as well. So we spent a lot of time talking about likelihood of confusion. I don't know if you see the light or it's more confusing to you. I know it's very confusing, and I talk to people daily about this. The problem with trademarks is you develop an emotional connection to something, and you think it's a really great idea, and it probably is. The problem is that you can't just go out there and look for an exact match. You have to be aware of this likelihood of confusion. And it's not a black and white test. It's shades of gray. So it's very, very difficult to get a yes, no answer. And if you were to ask me whether something was good or not, I couldn't even say yes or no. I would tell you high risk, medium risk, or low risk. And nothing annoys the hell out of a client more than when I say it's a medium risk. I don't know. If they want to make an issue out of it, they can. If they don't want to make an issue out of it, they won't. Nobody likes that. And nobody likes when I say low risk and then I miss something, because it's just, it's so complicated and there's these shades of gray. And then I make a decision on this side of the coin and the USPTO decides to disagree with me and make a decision the other way. So it's not an exact science at all. I have Catherine asking a question here. Can you have a pending registered trademark? And there must be more to that question, Catherine, because the answer is of course. And let me explain what I mean by that. If you registered your trademark today, it's going to take the US Patent and Trademark Office 3 to 5 months to come back to you and tell you yes or no. So between the time we register today and 3 to 5 months from now, when they come back to us, it's pending. And then guess what? When they come back, they may say refused. And by the way, if you try to do it yourself and you're not a registered trademark attorney, or if you use one of those internet companies, and that's my last bullet is why I say this, there's over an 80% rejection rate on your trademark application. I'm not zero, but I'm not 80%. I'm somewhere around 20%. And the reason I'm 20% is because I tell my clients, bad idea, and they still want me to push it through with the hopes that it might work. And they're the clients. I'm going to do what they say, even though I've done my job to tell them that I think it's a bad idea. So I still have rejections myself, plus the fact that every once in a while I get surprised by something. But if it's not refused and it's approved, then in about 3 or 4 weeks, the USPTO is going to publish for opposition for 30 days. So we have a few weeks, then we have the publication for opposition, and hopefully nobody objects. But if they object, that's a whole nother story. Then if they don't object, then the USPTO is going to get back to us within a few weeks saying, no objections, congratulations, it's going to be registered. And then the USPTO takes its sweet time to go and register it. So another few weeks for there. So another 3 to 5 months from approval to actually getting registered. So you have a good 6 to 10 months between starting the process and finalizing the process to get your mark. So the word pending is within that time frame of things going and being activated. So if somebody has a pending mark, you need to be aware of it because that could be a problem once it's approved. Now, if they've filed, even though you were using first, you have priority if you were using first, but now you got to fight for it. And you do that by waiting for the opposition period and then filing an opposition. And if you miss that period, then you got to go and actually do a C&D, cease and desist, and get them to stop, or do what's called a coexistence agreement. All of this stuff we lawyers love because it's expensive. It takes a lot of work. And so it's a lot of legal fees. And so if you want to spend a lot of legal fees, I'm your man. If you want to avoid that, then you want to go through the effort of trying to find another name, which is really frustrating. And I get that. And I'm sorry about that. But you want to follow these steps. And I always advise people, fall in love with more than one name. Be clever, suggestive, not descriptive. And then you could do your own search. You could go to this link I put here at the uspto.gov. It's test2.uspto.gov. So you can do your own searching, and you got to get clever, and you got to do a bunch of searches, and you want to, look in your class code or category for the product or service, but also related categories. It can be frustrating. So one suggestion is to pay somebody to do the search for you, but you don't just want the results. You need somebody to interpret those results for you and give you some guidance on whether you're going to have a problem or not. And then my advice is reduce your list to 1 or 2, and then try and register both of them. If you have the time, register both of them and see which one you can protect. If you're starting to use it already, well then, okay, you're using it already. Don't file 2 marks, file 1. But I always recommend doing the trademark search first, because remember what I told you, 6 to 10 months before you get it approved, 3 to 5 months to find out if you have a problem or not. And if you're infringing somebody else's mark, you're spending money doing social media, getting laser engraving on your windows, you're spending a lot of money, maybe building an expensive sign out front that you're going to have to go and change and possibly defend yourself on a trademark infringement suit. So it always helps to be aware of what's going on before you dive into all of this. Catherine says, we have a registered trademark and want to add another conjunctive product with an abbreviation of the already registered trademark. We have a trademark attorney just using this webinar to increase your knowledge. You're welcome, and I wish you best of luck at that. There are a whole thing, things called family marks, which your trademark attorney might talk to you about, where you might have one general mark, and then you can feed off of that specific mark with kind of leaves off a tree kind of thing. There's a lot of value in doing something like that, if that's of interest to you. The other thing is, so after you do your research, I recommend you use your trademark ASAP. And the reason being is there's 2 issues here. First, using, that matters a lot, and then filing first. That matters because it reduces your costs. First use matters because it gives you priority over everybody else. And here's what I mean by that. If you start using your name today and somebody else, you don't register the trademark, you're just using it, and then somebody else next year goes and registers that trademark and they haven't used it yet, well, you will ultimately win. You have legal priority over the later comer, but you got to fight for it because they filed first. So the best of all worlds is to use first and file first. And then it's very inexpensive. You don't have to fight for anything. They got to fight. Okay, it might get expensive if somebody else fights, but they got to fight for a reason. They got to argue they were using first over you. So use first and file first. That is always the best. And you can also register yourself by going to TEAS at uspto.gov. So TEAS.uspto.gov. But I want to warn you, there's an over 80% rejection rate when people file themselves or when they hire an internet company. And so, I recommend you hire a trademark lawyer. Do not do the discounted stuff online, because all they're doing is asking you basic questions, taking garbage in and garbage out into the application, and they're going to do whatever you tell them to do without actually talking about the issues with you. So you really want a lawyer to help you with that. And that's my biggest problem competing on the internet, by the way, because I have people who are price shopping and they're like, well, Larry, you charge $200. Why should I go with you versus the $43 person on the internet? My answer every time is go do business with a $43, company on the internet. And then if you have problems, come back to me. And I make a lot of money on the bigger problems, the fighting and the, redoing the application because it wasn't done correctly. And so for you to save some money, work with a good trademark lawyer is my suggestion. Also, I do want to recommend SBDC because they have some really great people available. And so I would highly encourage you to consider consulting with them. They aren't trademark people. They're not lawyers. They're coaches, they're advisors, and they can help you think through a lot of the issues, make introductions for you. For instance, if you're having trouble coming up with a suggestive or descriptive mark, they might be able to recommend some brand folks for you. So they're a great source of references and people for you as you move forward with your business. And I want to give you a couple of real quick world examples. And I mentioned Redbox already. You may have saw, I talked about translations, red and rojo and cube and box. And this is an actual thing. Somebody tried to go after cubed rojo and it was declined because of Redbox. And you just take those 2 words, swap them. One's a translation and one is a synonym. That's going to get you into trouble. Annalena mention, by the way, check the chat. There's a no-cost counseling that you can register for with them. Let me talk about Melon Rancher briefly. That is a e-cig fluid, a flavor that a client of mine used, and they sold it in conjunction with 100 other e-cig flavors. Well, Jolly Rancher had a problem with that. So they went and came after my client saying, hey, you're infringing our mark. My client's like, this is Melon Rancher, they're Jolly Rancher. And I had to explain the likelihood of confusion to them. And so my client said, fine, we'll stop using the name. That wasn't good enough for Jolly Rancher. They said, nice try, but we care a lot about our name. We care about candy. We think e-cigs is a sin. We, don't like you. And the last thing we want is any kind of relationship between these two. So we're really upset. You need to pay us our legal fees. And oh, by the way, we want to disgorge your profits. So you need to tell us how much you've been selling the Melon Rancher fluid, e-cig fluid. How much have you been selling that for? How much money have you made? Well, my client said, I don't know. We sell 100 different fluids. People show up at the store and they'll buy 5 or 6 fluids and we just ring it all up as one. And guess what Jolly Rancher said? That's great news for us because it's not our responsibility. We don't care that you don't know how to keep proper books and, take into account how much you're selling or not of your various fluids. We want to know what the profit and losses of the entire company. So that ended up being the big debate as Larry the lawyer. I had to argue with them and try and negotiate down and say, okay, wait a minute, Melon Rancher is 1/100th of the fluids we sell, and therefore you should look at 1/100th of the profits. You can imagine where that debate went, but we were able to negotiate something down. But they spent a lot of money on me, and then they had to write a check over to Jolly Rancher to, avoid going to court. So you don't want to let that happen. Finally, Holy Cow, that is the hamburger restaurant on Central in Albuquerque, some of you may know about, and they were using that name for 7 years. And finally, the Holy Cow folks in Chicago, Harry Carey of the Chicago Cubs started a restaurant chain in Chicago and finally went after them after 7 years. And the thing with Holy Cow is here, they thought they were safe because, Harry Carey's in Chicago, and that's not the way it works. If somebody has a federal trademark, they have to police it, and they're eventually going to go and find you, even if you're in a small little, state called New Mexico, in a small little city called Santa Fe or Albuquerque or Rio Doso. So that's all I have. We got a couple of minutes for some questions, if there's any.
Well, I also want to let you know that we have Estefanita Rawlings with us today, and she's going to hate me because I'm putting her on the spot, but she is the Center Director Coordinator for the New Mexico Small Business Development Center Technology Commercialization Accelerator, which I know that's a mouthful, but she works with clients regarding their intellectual property. So we have all kinds of resources available. And if she does want to talk, I can allow her to talk. She's going to be going, oh, Leslie, what are you doing to me? But she might want to say something about what other services that we can offer as far as trademarks.
Can you hear me?
Yes. Hi, Steffi.
Hello. Thank you, Mr. Donahue. I think this presentation was very good. My name is Estefanita Rawlings, and I'm with the Technology Commercialization Accelerator here at New Mexico Tech. And so we've been here a year. We started in March of last year. And so we offer no-cost confidential counseling to our clients regarding intellectual property. And just like you, we just showed them where the USPTO, we have the trademarks and the patents there and the copyrights at the Copyright Office. And we do recommend that our clients use a lawyer just for those reasons that you were talking about. And we just expose them to the process of what it takes to get a registered patent or a trademark. So, but We will be having a big World IP presentation April 26th. So we are going to have the USPTO here, and we're just going to celebrate intellectual property. So that's real exciting that we're looking forward to April 26th. But thank you. Thank you, Annalena, and thank you, Larry, or Mr. Donahue.
Yeah, Larry's fine. Thank you.
Thank you.
And with that, we are right at the end of our webinar. So do you have any last words, Larry, before we dismiss everyone?
I appreciate everybody's time. We do, the presentation is available by contacting the SBDC. So you can get a copy of that, and you'll have access to the links and resources available should you need it. And we wish you the best of luck, and take care. Stay safe.
Thanks, everybody. You guys have a great day.